Hello and welcome. This is the Public Affairs Forum, sponsored by the First Unitarian Universalist Church of Austin, Texas. My name is Luther Elmore. We hold these forums most Sundays here at our church, and the purpose of these forums is the mission of the church to nourish the mind and spirit and to inform and inspire. We invite you to join us here at our church location, 4700 Grover Avenue in North Central Austin. We've been holding these public forums since the year this church was incorporated, 1954, and as far as we know, it is the longest serving public affairs forum in the state of Texas. They're held Sundays at noon. They're free to anyone who wishes to attend. We invite you to attend where you can ask your questions of our presenters. Today, we're very happy to welcome Dr. Zachary Elkins from the University of Texas. Dr. Elkins is an associate professor in the Department of Government at UT. He earned his BA from Yale, his master's from the University of Texas at Austin, and a PhD from the University of California, Berkeley. He recently completed a new book, The Endurance of National Constitutions. This explores the endurance of various nations' constitutions. Along with Dr. Tom Ginsberg from the University of Chicago, Dr. Elkins co-directs both the Comparative Constitutions Project. This is a National Science Foundation-funded initiative to understand the causes and consequences of constitutional choices. He also co-directs the website constitutionproject.org, which provides resources and analysis for constitutional drafters and new democracies, with a special emphasis on Latin American countries. Dr. Elkins is considered one of the finest constitutional scholars in America, and it is with great pride we welcome him to our forum today. Dr. Elkins.
Thank you, Luther, for those very kind words. It really is quite an honor and a privilege to be here with you today. I would say guns is one of those topics, one of the most polemic and polarizing topics that I work on, and already we are in a very polarized atmosphere, as you know. I think it's fortunate that we have some distance between us and the last national tragedy involving guns, and I say it's fortunate because in many ways what I'm going to argue today is that we need to lower the temperature about the way we talk about guns and remove ourselves a little bit from the hysteria and the emotion involving that topic. I would say we're also at a moment, and maybe people say this all the time, but I think we're a moment in which it's right to start thinking about our national institutions and our constitutions. And not just because of the 2016 election. I think this has been going on for some time. I've noticed that people have the appetite now to rethink the way we do politics and our system of government in this country. Guns, then, it might be just one window into that. Now, one thing I've learned in thinking about guns is that it's a very local matter. And let me just ask you, those in the audience, how many of you grew up in an area that's more rural than Austin, Texas? Okay, so many of you. And you probably realize the approach to guns is going to differ very much from the place that you grew up in Austin, and it's going to differ considerably between Manhattan and Manhattan, Kansas. Context matters remarkably in anything, but particularly with respect to our approach to guns. I grew up in the New York City area, and I don't think I remember anyone, family that hunted or had guns for their protection, to my knowledge. Of course, it very well may not be to my knowledge. But having moved to Texas, I realized I have a deeper appreciation for gun ownership, and I understand it in a much more fundamental way. I have a very constitutional approach to guns, and you could think about guns in many ways. You can think of it as a public safety issue. You could think about their use for military purposes, any sorts of kind of thing. But I have a very constitutional approach. And it's part because I'm a constitutional scholar, and if you have a hammer, everything looks like a nail. But it's also the case that I think that this is an issue which hinges critically on the way it's framed in our Constitution. I have an opening screen here that has the text of the Second Amendment spelled out in the shape of an assault rifle, and it's actually quite hard to see. But if you straighten it out, you can see we have a very simple clause in our Second Amendment, seemingly simple. It actually is confusing for many people, constitutional scholars, justices, and citizens alike. And that really is my central point here, is that I think, despite the confusion that exists even on the Supreme Court about this clause, there is widespread agreement among the American people about what to do about guns, at least constitutionally. And I think that this disagreement leads to hysteria, leads to defensiveness and insecurity on both sides, and does not allow us to have this fundamental national conversation about what to have about guns. Okay, so I would say that this is the Second Amendment as has existed, and I need to call attention to a great way to read the Constitution. If on your phones or any device you were to search for U.S. Constitution on Google, you would have this index card that comes up as what's called a one box on a Google search result. And there you could actually page through the Constitution in a really fabulous way. And this comes out as a result of a collaboration between my research team at Texas and Google, which allowed to take, we have a repository of the world's constitutions, and we set that up as structured data, which allows a search engine to take it and put it there as a one box. And so the U.S. Constitution, all this to say, it exists as an index card on your phone. If you were to search for U.S. Constitution, you can page through it in a really wonderful way. Now, the Second Amendment, as I'll argue, has a very simple reformulation, which I think would have really enormous effects. But the background of this has to do with whether we can actually enact this sort of change. The background is, of course, what seems to be the immutability of the U.S. Constitution. And in his introductory remarks, Luther mentioned this book that I wrote with Tom Ginsburg and James Melton on the endurance of constitutions. And what we did in this book was to look at the chronology of constitutional changes across every single country in the world and get a sense of how often they changed and what the risk factors were to replacing somebody's constitution. It turns out, like everything else, the U.S. is exceptional. It's an outlier. We've had the same Constitution for our entire lives. Well, two, if you count the Articles of Confederation, which most of us don't. But the same Constitution. And this differs remarkably across countries. So some of you might know the joke about the French Constitution. A guy walks into the library, asks for a copy of the French Constitution, only to be told by the librarian that we don't stock periodicals. Thanks for that laugh, because constitutional humor is in short supply. That's one of the few things we have. But it turns out, so France has had 14 constitutions compared to our one, and it turns out that France is much closer to the rest of the world than we are. There are some, at the extreme case, Haiti and the Dominican Republic have had 30 constitutions in their 200-year history, so one every 7 years or so. That accounts, the constitutions from that island of Hispaniola, which includes those two countries, accounts for 1/10 of the world's constitutions. So that is the place to go to study constitutions. But on average, if you look across constitutions, they last about 19 years. That's the life expectancy of a constitution compared to our 200. And there's something eerie about that number, actually, because some of you might recall this debate that went on via a correspondence across the Atlantic between Thomas Jefferson and James Madison. And Thomas Jefferson was advocating that our Constitution, and actually all of our laws, self-destruct every 19 years, with the idea that you can renovate our laws and have some higher degree of representation. Madison, who of course wrote the Constitution, was not in favor of that. It was an interesting debate, but it turns out that Jefferson's prescription, that is, that they self-destruct every 19 years, is exactly the amount of time that we would expect a constitution to last, 19 years. So it's somewhat eerie. Now, and not only that, so the U.S. Constitution it hasn't been replaced, but it's also very hard to amend. And this is one of the reasons why it's surprising that it's lasted so long. We've only had 27 amendments, if you count the first 10, which were done as a batch right off the bat. And the last one was in 1992, which incidentally was the work of a UT undergraduate, and it's a really fascinating story. If you haven't heard it, I'll tell it at the end. But all that to say is that it's very hard to even amend the U.S. Constitution. There have been 200 amendments every year for a total of 10,000 in our 200-year history, and none of them actually get through. Why are we talking about amending the Second Amendment when it's almost virtually impossible to do so? Well, it's interesting to think about what our Constitution would be like if we were to amend it, if we were something like France, not to speak of the Dominican Republic. Well, one thing we would probably do is not include the Second Amendment. There are very few countries that actually do that. Here's a chart. For those who can't see it, this is the proportion of countries that have the right to bear arms. And if I were to plot the proportion of countries that have a given right across the 120 rights that have found their way into constitutions, you would see that every single line goes up. The popularity of a right virtually always goes up. It's like a one-way ratchet. Once you've introduced a right into the world's parlance, everybody adopts it for the most part, in part because in constitutional assemblies, it's really hard to argue against a right. So the path of least resistance is to adopt it. Not so with the right to bear arms. There were a smattering of countries that had it, mostly in Latin America, in part because they modeled their constitution after ours. But over the years, as they replaced or amended their constitutions, they either eliminated that right or changed it dramatically. For the most part, they changed it to allow citizens to keep arms, but not to bear arms. And the definition there is actually keeping a gun in your residence as opposed to carrying it outside your residence. And that was actually very few countries that decided to keep it, as you can see. We're left now just the three countries, Mexico, Guatemala, and the United States, which any real sense of the right to bear arms. So all that to say is that if we were to rewrite the US Constitution, we probably wouldn't include it. And I should say, if you want to look at the text of those clauses on the right to bear arms or any other clause in the Constitution or across the world's Constitution, we have a repository of constitutions which we established with Google, and it's an indexed repository of constitutions. So if you want to know what every single country says about, say, the right to privacy, you can search in our repository and in a very beautiful way take those excerpts, analyze them, and think about it. It's a way for drafters who, as you probably know, are often plagiarizing other constitutions. It's an opportunity for them to look at other models and understand options better. Okay, but back to the Second Amendment. The Second Amendment really has two clauses, a prefatory clause and an operative clause. The prefatory clause, a well-regulated militia being necessary to the security of a free state, in some sense, and for many people, gives the justification and the rationale for the right, and so it is a right of collective security against tyranny. The operative clause, as it's called, is the right, stated very clearly, the right of the people to keep and bear arms shall not be infringed. So those on one side of the debate pay attention to the first clause, and those on the other side of the debate pay attention to the second, and very rarely actually pay attention to both. Now, for most of our history, this right was not litigated or adjudicated by the courts, or at least not by the Supreme Court. Until 2008, there's a case, the District of Columbia versus Heller. And this is really the first real case on the Second Amendment in our 200 years. And for many years, jurisdictions, local and state, had put all sorts of regulations on guns. So even in Tombstone, the site of the shootout of the OK Corral, even there, the authorities required people to check their guns before entering town. So there were all sorts of regulations on guns, and they were never adjudicated in the Supreme Court. Nobody had seen fit to litigate them. Until 2008, in this case, and this is a case in which Heller, the named claimant, contested the District of Columbia's law that essentially banned handguns, and made the case that this is a violation of the Second Amendment. Now, the justices ultimately sided with Heller in a 5-4 decision, which, no surprise, I guess, went along party lines. And that's probably another concern for many people in our polarized climate, is that the decisions go along party lines. But the decision, if you were to read it and listen to it, and by the way, Supreme Court sessions are really quite fascinating, and I find it troubling that we can't actually listen live or watch live these discussions, because, as I say, a national conversation about our rights and our Constitution is interesting, important, and not only that, it makes very vivid watching, and it's something worth doing. But if you listen to that debate, you see that it was utterly polarized. They talked historically about what it meant to keep and bear arms, and there's a very semantic discussion about what those words mean and meant 200 years ago. But they also disparaged each other in really rather crude terms. Many of the other side's opinions were described as wrong-headed, plain wrong, and my favorite, dead wrong. And so they didn't mince words. So for those of you who think these Supreme Court justices are operating in a very subtle, nuanced way, no, the conversation goes along the same lines we might have about these things. So there was endless discussion among these justices, and without reaching much of an agreement. In fact, I would say that these justices were just as confused and just as divided about the Second Amendment as we might be. And that's a problem, I find. Now, that decision was 5-4, and Justice Scalia, who now has left us, wrote the majority opinion. And he was actually responsible for many of the uses of the term wrong, I should say, in both the hearing and in his opinion. But with him gone, of course, the court remained deadlocked at 4-4 between the liberal and conservative justices. And so this was, of course, the setting, really, for the 2016 election. And if you were to look at the election from the perspective of gun rights, you would realize, I think this is one of the narratives of the 2016 election, which didn't come out too much, but of course, those on both sides were suggesting that that election would have a lot to say about where gun rights would go. So Ted Cruz, for a while, before Trump edged him out, his stump speech largely talked about saying we were one justice away from losing the right to bear arms. And Hillary Clinton, I think she was sensing some weakness on Bernie's part, pushed the gun issue aggressively. She had, I have to think, had field tested that line of argument quite a bit and realized that there was some resonance of American people after the Newtown disaster, et cetera. And so there was a real sense in that election, for those who were paying attention to gun rights, that thing could go one way or the other. Justices could have decided, by the way, the DC versus Heller decision essentially said there's an individual right to bear arms, as opposed to some collective right to confront tyranny, et cetera, as a militia member. But it also had some very nuanced words at the end. Scalia wrote into his decision that a lot of the conditions and restrictions that jurisdictions would put on guns were probably valid. You just couldn't prohibit guns. So it was a somewhat nuanced decision, but the headline was, there is now an individual right to bear arms. And what happened after that is there was a cascade of cases that went between courts all across the country, before courts all across the country, litigating, contesting restrictions on gun rights. So it opened the floodgates to some extent on that. And I would say one thing that hung in the balance, of course, was who was going to be appointed to replace Scalia. And as we know, President Obama did not have the opportunity to do that. And that fell to Donald Trump, who appointed somebody who has probably no intention of overturning the Heller decision. The liberal justices on the court are waiting for an opportunity to overturn Heller and essentially say that there is no individual right to bear arms. So we're really on the precipice. And the point is, being on the precipice, this uncertainty feeds the hysteria, paranoia, and insecurity of people on either side. And I think prohibits us from having a real conversation about guns. Now, I want to digress a little bit to political polarization, only because I find this is another necessary point of background about this debate, and is unfortunately one of the distinctive characteristics of our politics right now. And I think we all sense that people are divided, that there's distinct partyism and polarization across party lines. If you look at some data, it's very clear that that has happened. If you look at public opinion polls for the last 20 years, you find, if you look at a cluster of policy issues, that the median Democrat and the median Republican are much further apart than they were in 1994. And that's not just citizens. If you take some political data on legislators, and you could look at how they vote, or you could look at how interest groups score them. In this case, I'm looking at how interest groups score them. In this case, the ADA scores, which will score legislators on how conservative or liberal they are on a scale from 0 to 100. And while in the 1950s, there were plenty of legislators who were in the middle, those are now gone. We have very few legislators, if any, who are in the moderate part of the spectrum. And that won't surprise anyone, of course. So that colors how we talk about guns in a very serious way. And by the way, I would say, I think we're all bothered by polarization, but I think what bothers people about polarization is not the heated political talk. I think we're okay with that. Everybody wants to talk about politics at least in a very rational way. But I think what bothers people about polarization is when you have it and you realize that deep down there's actually probably consensus and agreement on a lot of issues. But we're fired up because we've taken sides and are arguing around the issues instead of about the issues. And I think that's the case with guns. You're probably wondering what citizens say about guns, because often what goes on in Washington and in the legislature is very different from what the citizens want. And you could take any issue, whether it be the Affordable Care Act or taxes. With respect to guns, we have a lot of public opinion data. And what I've learned is that citizens are, for the most part, in agreement about a lot of things. One thing they're in agreement about is whether there's an individual right to bear arms. And it turns out that 73% say that the Second Amendment includes an individual right to bear arms. Another large number has no opinion, and 20% say that it doesn't. And if you look at those who own guns versus do not own guns, even those who do not own guns, a majority of them say, 63% of them say there is an individual right. Of course, those who do own guns, almost all of them agree with that. 91% of them agree. And what's also interesting is that since the Newtown tragedy, this sense among the American people that there is an individual right has only increased. And so if you look at data that asks, a question that asks people, is it more important to control gun ownership or to protect the right of Americans to own guns? It used to be in the 90s that a majority of people would say it's more important to control gun ownership. These days, that's flipped, and people are on the side of an individual right. And I'll talk about the flip side of that consensus in a little bit. But if you actually go to the nitty-gritty and the detail of what you would do about guns, you'll find on many of the issues in terms of licensing, approval of gun models, other restrictions that localities might put on, Republicans and Democrats are not that far apart, which belies, I think, a lot of the general polarization and also the polarization regarding guns. Now, what I think is that if we reformulate and revise the Second Amendment, we're going to solve a lot of our problems. And let's go back to the text of the Second Amendment. If you remember, there's the prefatory clause about the militia and the operative clause about infringing the rights. And if you were to make some changes, what would you do? Well, on the left, it's very clear what you would do. You would maybe get rid of that operative clause, but at the very least, you would change it so that it emphasizes the bit about the militia, the bit about it being a collective right, not an individual right. John Paul Stevens retired from the bench and suggested exactly this. He wrote a book identifying 6 amendments to the U.S. Constitution that we should take up. And this is surprising for a court justice who's used to interpreting and adapting this archaic language to modern life, and used to interpreting as opposed to writing. It's interesting that they would actually suggest some revisions of the document. Well, Stevens had an amendment regarding guns, and this is what he said. He tacked on the words, "when serving in the militia." So it emphasized the prefatory clause and made very clear that we do not have an individual right. And this is what terrifies the NRA. This is what terrifies Second Amendment advocates. The idea that not only do Supreme Court justices disagree with the collective or the individual right to bear arms, but also they're willing to suggest an amendment to the U.S. Constitution to that effect. Now, that's one side suggestion for change. The other side would be something like this. And this is a cartoon, of course, of a Supreme Court justice with an assault rifle blowing away the prefatory clause. The cartoons, by the way, on the Second Amendment are really quite good, and this is just one of them. And but to put it in plainer terms, this is what they would do. Get rid of the prefatory clause on the collective right. And you'll see if you go to demonstrations of Second Amendment advocates, they hold signs that emphasize the second part and not the first part. So it's clear what that side would do. I've got a change that I think strikes an agreement between these two sides, and I think actually articulates the consensus that exists in American society today. And that is that I think there's no appetite for prohibiting guns. I think people recognize, for the most part, that that train has left the station, and there is something of an individual right to bear arms. And this has to be the assumption that we agree that there are some reasonable, there's some decent reasons, legitimate reasons to own a gun, whether it be for hunting or for protection. And I think people recognize that. On the other hand, the other thing people recognize, and this goes for gun owners and non-gun owners alike, is that there's some reasonable regulations that should exist to protect public safety and public security. I think that's a reasonable thing to say, and if we were to rewrite the Second Amendment, that's what it should say, and I'm suggesting these words. The right of the people to keep and bear arms shall not be infringed except by reasonable measures to protect public safety and health. Now, one thing about this is that this, for whatever reason, articulates, I think, the decision in the Heller decision. This is what Scalia was basically saying, but it's not how it's written. And how it's written really matters, because how it's written exacerbates tensions and riles up people on both sides. So there's a good reason to rewrite it, but sophisticated people might say, well, if the court is really going to just pay attention to the Heller decision, why do we need to rewrite this? Because what really matters is how the court interprets this in light of the Heller decision? Well, there are two reasons why we should rewrite it. And one is because I think we need our higher law to operate as a foundation for innovation and for sound policy making. And it's really hard to balance freedom and security. We know that in all of our laws. But we've learned how to do that to some extent with all sorts of dangerous substances, whether it be drugs, alcohol, whatever it is. We've learned in the different jurisdictions how to deal with it. But it's hard. We need to innovate. We need to experiment with different policies and different rules. And because of the polarizing, hysterical nature of the Second Amendment, I feel like this stifles any innovation along these lines. Jurisdictions, let's say Austin, are going to be loath to inject any restrictions in only because they fear litigation from Second Amendment advocates who, understandably, are insecure about losing the right to bear arms. And in terms of innovation, there really are some interesting things that we can do out there, and all these things, as I said at the outset, should be tailored to the locality. But some of the interesting things that could be done are the things that are done in all sorts of other dangerous things. We could have a pre-approval for gun models, much the way we do for drugs that are before they go to market. We could have insurance programs that gun owners would take out much the same way we do for drivers of automobiles. We could experiment with the requirement of smart technology for guns, whether they be micro-stamping, shell casings, trigger locks, etc. That's the sort of thing that we should be experimenting with. There's 65 people who die every day as a result of gun deaths. And none of this stuff is going to get that down to zero. But I think the way to think about this is to get 65 down to maybe 60 or 55 or 50. And think about the same way we think about automobile accidents. We're not going to eliminate them, but let's see if we can make them as safe as possible. And the hysteria around the Second Amendment just doesn't allow us to do this. I think the other reason to do this is that we want a Constitution that is meaningful and reflects the way we feel in this country. And I think if we were to have a national conversation about what we want in terms of guns, it would be something like that text that I introduced earlier. It's very helpful to have higher law that is consistent with our values. It allows people to operate and build institutions and laws in a very reasonable way. And it also is nice if citizens can actually understand the Constitution. I've already stipulated that Supreme Court justices can't reach agreement about what the Second Amendment means. We can't expect citizens who aren't spending their days reading law to agree either. And constitutions, they're not supposed to be credit card contracts. They're not supposed to be something they're supposed to be something you read. They're not supposed to be written in these hieroglyphic codes that only those trained in the law are able to understand. This is supposed to be plain English, and we're supposed to understand them. And I think it makes sense to have higher law that actually reflects how we feel, but is also, as representative of how we feel, but also is meaningful and intelligible. Okay, so, and moving towards a conclusion here, I want to think about the prospects for change. And I opened with some background on the US Constitution and how hard it is to make any changes, how hard it is to replace it, much less how hard it is to actually make small revisions and amendments. It's exceedingly difficult. And many good people have made suggestions for change. I am one who's quite attached to the US Constitution. I think having a stable document is helpful, and one that stability has allowed us to prosper both economically and politically, and there's good reasons to be attached to the document. On the other hand, I also realize that this is one of the first modern constitutions. And political scientists have figured out a few ways to do things better. There are many suboptimal aspects of the US Constitution, and often that doesn't matter. We're very highly adaptable creatures, and we can make do with whatever law, probably. But some things, and you probably noticed a lot of the dysfunction in Congress, some things can be changed rather easily, and there are a lot of options out there in the world that are worth experimenting with and thinking about. I think Madison, who was the architect of the U.S. Constitution, would agree with this. I have a line which I like, which is, if you were to sit James Madison down in a Boeing 787, give him an iPhone, and allow him to FaceTime with Thomas Jefferson, he would probably turn to us and be incredibly surprised and a little disappointed that we're still using the Constitution that he and his peers wrote one summer in Philadelphia 200 years ago. There is a section, Article 5, that allows us to amend the Constitution, and he intended, and his peers intended us to use it. Now, I want to close talking in a somewhat uplifting way about how that actually happened in Austin, Texas, 25 years ago. And some of you may not know the story of Gregory Watson. He was an undergraduate at UT at that time, and he was taking political science, or Government 310, which is a large introductory government class, which incidentally is required by the Texas Constitution. And I, as a political science professor, I love that part of the Texas Constitution. But anyway, he was there because of that, and his professor at the time, Sharon Waite, had required them to write some paper on the process of government, or something like that. And at that time, the Equal Rights Amendment was in the air, and it had been proposed but not ratified by 3/4 of state legislatures. Of course, we know the ultimate end of that. It never was, and most amendments have an expiration clause, and that one had a 7-year expiration clause, the Equal Rights Amendment. So it expired without 3/4 of state legislatures taking it up. But what Gregory Watson discovered in his research was that there was an amendment that had been proposed by James Madison 200 years ago. It hadn't made it into the Bill of Rights like the others. It was an amendment essentially not allowing legislators to give themselves a pay raise in the same Congress. They had to wait for the subsequent Congress for that to be approved. So it tried to militate against self-dealing in terms of compensation. And he thought, well, that's a sound idea. Why should we let them pad their pockets? And so, James Madison proposed it, and there's no expiration clause. So he proposed in this paper that it be adopted, that state legislatures actually vote to ratify this. And his professor at the time gave him a C on the paper. And she thought her explanation, and the TA's explanation, was that it was not a feasible project. And Gregory was appalled. And he's the kind of individual, as I've come to learn, because I've got to know him quite well, actually, who doesn't take no for an answer. And so that summer, he started a letter writing campaign in which he got another 15 state legislatures to ratify that archaic amendment. And as a result of that, it became the 27th Amendment to the U.S. Constitution in 1992. It was a miraculous achievement. You know how miraculous it is to amend the Constitution at all, much less for a sophomore at the University of Texas to affect that change is even more remarkable. And so I like his story because it's one of defiance and redemption, and I'm sure we love those kinds of stories. In any work of fiction or any film or any song, there is that person, that underdog who's second guessed, who comes from out of nowhere to redeem himself. And I'm so impressed with his story. Last year, I decided we at UT needed to do something about that. And so I contacted his professor at the time, Sharon Waite, who had since left UT shortly after Gregory left, actually. And I suggested that we change his grade from a C, and I said A+. And now the University of Texas does not give A+. But I argued to our registrar, this is the one time that we should give an A+. The registrar is a very difficult part of the UT bureaucracy, and so they didn't give in on that. But they did accede to our wishes to change his grade to an A, which we did. The registrar told me it was the longest time that it ever passed between the grade and the grade change, 25 years. But we did it, and Gregory's pleased, everybody's pleased, and I think it recognizes one thing about the U.S. Constitution that is really difficult and hard to change, but if an undergraduate at the University of Texas can do it, I think we can all do it. So I'll leave it there and be happy to talk with you about any of this, questions, comments, anything.
Dr. Elkins, thank you for your comments, and your topic and discussion might have generated some questions by some of our audience, and if you would keep your questions very short, to the point, so that Dr. Elkins can answer as many as possible. And as I come to you, would you please identify yourself?
Hi, Ed Underhill. The term "the people," isn't it like loaded and too poetic? Well, shouldn't it be each person or something like that?
Yeah. Should I take these individually or as a bunch?
Please.
Okay.
Please.
I don't have a considered opinion about that use of the term, and I realize in constitutional jargon it has a very weighted and freighted meaning to it, and it suggests that we're all homogeneous and monolithic in our preferences, and as the polarization issue is made clear, that's certainly not the case. And so your reformulation of that would probably be more accurate for those reasons. Yeah.
Hi, Professor Richard Halpin. Thank you so much for your comments, and the width of your research is terrific. I'm curious about the Elkins Amendment. The Elkins Amendment, when it talks about accept by reasonable measures to protect public safety and health, couldn't we have thought at the time that the British thought they had reasonable measures to protect public safety and health? And doesn't that give too much of a vague sense of what the state can say is reasonable?
So that's a very good question. It is vague, and I think those on the side of one side or another might actually object to it for those reasons. I would say a couple things about that. The British, of course, in their Bill of Rights, had a right to bear arms. In their formulation, it was just for Protestants, but that's how you wrote things in the 1600s after Anne Boleyn, etc. But they certainly had that, and it is true in our founding that we felt the need to articulate it that much more clearly and to make sure that we would have access to guns in the case we needed to organize and coordinate and face tyranny. What I find is over the last couple hundred years, when I look at the history and I look at disagreements in the American public and I look at the possibility of the federal government's intrusion into our affairs, that the access to guns wouldn't have solved too many of those problems. So I'm not, when I look out at disgruntled Americans and paramilitaries that are existing on the fringes of the American society, my sense is that arming them is not the right thing to do. There are some groups in American history that I think would have benefited from this, and I think African Americans in the American South would have had a decent argument to keeping arms to face collective tyranny, because what did African Americans face if not tyranny? On the other hand, I think we've learned, and probably only in hindsight, is that the approaches they took and that Dr. Martin Luther King took is a much more peaceful approach, was much more effective than would have been something that was much more militant and much more aggressive. So in that sense, the one group that I think would have made sense to arm to confront tyranny, I think was much more successful in a more peaceful approach. As for your question about reasonable measures, I think this is vague, but I think over the last 200 years, each of the localities have adopted regulations on guns, and this is before the Heller decision, that people saw as reasonable. That is, city councils and state legislatures in part because of the highly politicized process, have not been able to enact regulations that are unreasonable, I don't think. We can go back through them, but yeah.
Are you in touch with any U.S. senator or representative who might be willing to introduce this proposed amendment so that in years in the future we'll talk about the Elkins Amendment to the U.S. Constitution?
I am not, as of yet, in touch with any legislator on this, but that is probably the next step. But it depends a little bit on how other people feel about this, because I'm not somebody to make I'm not like Gregory Watson. Let's put it that way. Yeah.
Try to keep my remarks short. I will try very hard. I am against an individual's right to have a gun. I don't think the Constitution, which people don't understand, was written for a different time. When you lived out in the open and you needed a gun to kill a deer, you needed, for food. Okay, we don't need that today. And what I don't understand is, why is it so hard to change the Constitution? But it seems to be that you've allowed the NRA to get so powerful. Why is it so hard to change this, as you indicated?
Yeah, that's a really great question. I'm sympathetic to your views, and many, of course, justices would agree that there's no individual right to bear arms. And I think you're right. Our Constitution was written for an agricultural society of 4 million people, in an age where muskets was the highest or most sophisticated armored firearm. We're in a very different situation now, and what may have made sense then may not make sense now. And I agree with my amendment. What I'm doing is in some ways acceding to that request or that argument that there is an individual right. But I think my sense is that people either accept that or probably have to accept that in order to actually get meaningful restrictions on the books. Now, why is it so hard to either change the Constitution or to enact sensible gun regulation? And a lot of that, as you suggest, has to do with interest group politics, which often far outweighs the voices of the rest of the citizens. And it is true that those on one side of this debate are much more vocal and much more intense than are other people on the other side of the debate. We have, Michael Bloomberg in New York has started to organize people on the gun restriction side of things, but he's never, I don't think, could ever mount anything close to what the NRA has done. And so we know that even reasonable people who would make restrictions on guns in Congress are held captive by these interest groups. And I think this is why, in some ways, people are in favor of things like term limits and other ways to get more independent voices in Congress that aren't captive, perhaps, to interest groups. And that's why I say having a national conversation about other aspects of the Constitution makes sense as well, because this is not just about getting the right language in the Constitution. A lot of this is about getting our government working and solving a lot of the pathologies of our government as well beyond the Second Amendment.
Jim Bryce, thank you very much. Very impressed with your presentation, which you started with a question about how many people were raised in rural areas. I raised my hand, many of us did. But you asked a location question, you didn't ask a time question.
Yeah.
And I'd like to submit and ask you in general about constitutional and this. It seems to me, in my experience, and I was in the midst of the tower shooting, which is over 50 years ago now, unheard of then, and for 20 years later, not heard of. Those of us who grew up in the 30s, 40s, and 50s had sort of an innate education from our grandparents, great-grandparents, going back to the frontier and the wars, of how to handle and respect firearms. And somewhere in the last 50 years, that idea has disappeared, and it's, in my opinion, is infecting everything now, that there's not a real understanding. That, I think, affects, and I'm asking you, if these social changes affect constitutions and how you can make that work.
Yeah. I think that's a very astute point. When I asked the question of this crowd, you and probably, I would have guessed 60 or 70 people said that they had grown up in a rural area and grown up at a different time, which is another great point. And I think it's quite possible that one's education about guns differs remarkably both across rural and urban settings and across generations. We're 85% urban. Most people are growing up in these cities without much of an education about guns or how to use them. When they come to guns maybe later, it's without that background, and maybe without the respect for their force and without the knowledge of how to use them. And that's a dangerous combination. Some of that might be able to be solved by more intense licensing procedures. You know, before I get behind the wheel of a car, I at least had to do a written test and a driving test. We might expect that for gun ownership. I think that's a reasonable thing, at least in some localities. One thing you said speaks, I think, to a larger point, which is the divide among Americans. And we talk about the divide across parties, but I think even a larger divide is that across localities, so between rural and urban Americans. And there's that monstrous gulf between those two groups with respect to guns, but I think that same gulf exists with respect to pretty much every policy issue. That what separates us largely these days is urban versus rural voters, and in this case, very clearly.
My name's Hamilton Richards, and I would like to hear your opinion about the two routes to amend the Constitution. Introduction in the Congress versus the Article 5 Convention. Could you compare those two?
Yeah. Now that is a very relevant point these days. Every single amendment to the U.S. Constitution, for the most part, for every single one, has gone through the one route, which is that 2/3 of Congress passes the bill, and then it's ratified by 3/4 of legislators. And we've talked about how hard that is. And of course, as you pointed out, James Madison identified a second route by which amendments can take, and that is one that would bypass the legislature. The thought was that we might get this recalcitrant, dysfunctional legislature. Imagine that. We might get that, and so if they can't reach agreement on anything, much less how to name a post office, then maybe we need to get to the people and let them be the ones to initiate an amendment. And so that's the second route. It hasn't been taken. And as you say, it's the calling of a convention of states. And if state legislatures, a supermajority of them, can agree to do that, and we're almost there actually, then we can have a convention and the people can take control of the process. Now, what's been interesting about this is that the proposal for a convention of states has come from conservative forces, mostly, and this initiated during the Obama years. And the thought was we needed a convention of states to strengthen the federal list component of the Constitution, that is to strengthen states' rights and local rights, and to keep the federal government out of it. And so the thought was, and our governor signed on to this, there was a 15 or 20 point program that would be taken up in this convention, and every single one of those things would intensify local control as against the federal government. Now, one of the issues since it's never happened, this convention of states, one question is whether that could be limited to those 15 or 20 points. Since it's never happened, nobody can say. People on either side are stipulating one way or the other, but of course we know when the delegates gathered in Philadelphia in 1787 to amend the Articles of Confederation, which was their charge, they did a little bit more than that. They ripped it up and rewrote the whole thing. So who's to say that if we did something similar at a convention of states, that all sorts of proposals would make their way in there? I, for one, even though I have a deep appreciation and attachment to the U.S. Constitution, and I feel like we have adapted ourselves to it quite well, I am one who thinks that there are enough good proposals for changing it that I'm not opposed to a convention of states to do that. I'm not sure that we would get agreement within that convention, but it's worth doing.
I'm Ellis Harris. I have a question about the case that recently happened about the ex-military guy who was charged with domestic violence in military court, and he should have not had the gun, but the military did not notify the gun people, and so he shot up all those people in the church. What is your opinion about that case?
Yeah. Well, that is an interesting case, and the result of that has been that both people from the liberal side and the conservative side are for once in agreement about that, about what should have been done. And this, of course, our Senator Cornyn was leading the charge about trying to make sure that the data about who is unqualified to have a gun is actually distributed and made accessible to gun shops. And so that's, what I find interesting about that is that's one of the few instances in which those on the right and left have come together and say, okay, this is a real restriction. Those who've committed these sorts of crimes shouldn't have guns, and let's make sure the data is there and intact to do that. And so that was, for me, that was nice to see because it made it clear that liberals and conservatives can agree about this. And of course, the reason they agree is that this is, kind of a very minor thing to do, to just, if your law is going to be in effect, let's make sure the data is right to actually enforce the law. The question is whether they would agree to enact other laws that would prohibit other groups from owning guns. As you know, we've had a really hard time passing legislation, even after Newtown, in the wake of that horrible disaster, legislation that would prohibit those on the terrorist watch list from owning guns. And if there's one thing that liberals and conservatives pretty much agree on is that they don't like terrorists. So if you're not allowed terrorists to own guns, then what other group is going to be prohibited? And so I find that incident was very dispiriting. On the other hand, once you have a law, I think people agree that, we can actually set up the institutions to enforce them. Yeah.
Dr. Elkins, thank you very much for your presentation. We appreciate your work and being with us today. Thank you again.